to introduce tonight's main speaker, Jeff Gordon. He is with the Worth County Planning and Zoning. He is the chair. Jeff?
Thank you. Can you hear me in the back and up top? Good. I'm gonna set the microphone down. I grew up in the Marine Corps just talking loud, so microphones and we don't work very well together. Make sure we get to the. There we go. Okay. So, well, first of all, thank you for inviting me to speak tonight. I think it should be, I hope it will be very informative. I do want to apologize up front when we get to it. We learned as we were doing a run through before the meeting that my last slide didn't make it onto the presentation. You're having a hard time hearing me? Okay. Right, is it on? Yeah. You hear me now? Okay, great. So the last slide in my presentation didn't make it onto the machine up top, and evidently it's a Mac and the tech guy was gone, so when we get to my very last slide, I'm just going to have to read to you what was on it. So again, I've got 8 slides tonight. I didn't create a 2-hour presentation. There's a lot of information involved when we talk about wind ordinances. So I'm going to put a highlight on some of the things that I think are critical about these issues. And I think there's some very strong parallels between what happened in Worth County and what is happening right now in Tama. After the presentation, I know they've got cards. If you've got questions, please write those down and provide them so that we can go through those questions in conversation and close any gaps that my presentation may have for you. I'll walk through what I think some of the parallels are between Worth County and Tama County, and then I'm going to talk about what our philosophy was in Worth County, how we went through this process, and then I'll go through a timeline of what we did and talk just very briefly on some of the things that are in our ordinance. Now, before I get started though, I do want to ask a couple of questions. I want to get a sense of the audience, and I want to make a couple of points later on. So how many people are in the room today are against wind turbines? Just show of hands. Okay. Quite a number of you. I would say a majority of the folks that are here. Now, how many people in the room today are in favor of wind ordinances, or in favor of wind turbines rather, under some common sense rules? A few people, okay? Are there any landowners in the audience today that have easements, that signed easements with the wind turbine company? No, that's unfortunate. How about government officials in the room? Supervisors, zoning commission, board of adjustment, anything? Got one? Oh, 2. Got 2? Good. And then are there any persons in the room tonight that work for an energy company that owns or operates or will be owning or operating wind turbines? None. That's unfortunate. You know, if you listen to who I was asking to raise hands, it really identified all of the different stakeholders that are involved in these questions. And I think it's important that we're all talking to each other and that everybody knows what's going on. And if we got folks that are not willing to engage in the conversation, then it's not going to work very well. So that kind of brings me to the very first thing of my presentation. It goes all the way back to the Constitution. You know, the preamble starts with, "We the people." It didn't go up. There we go. It says, "We the people of the United States." Excuse me. It then goes on to present why the Constitution is necessary. Essentially, as it was established in the Declaration of Independence, it establishes that the people are the entities that are vested with the inalienable rights. the people decided that in order to guide a civil society, some government was needed to establish some common rules under which that society would operate. But it says that the government was formed for the express purpose of protecting the people's rights via establishment and enforcement of the rules necessary for a civil society. So those, plus the protection of life and property, are the fundamental reasons for government rules. So that's why the rules exist, that's why we have them, is to maintain a civil society. Now, we saw from our show of hands that there were some people here from a variety of different groups. Unfortunately, we don't have all the various groups that were represented tonight, but the reality is, if we're going to protect everyone's rights, then we're going to have to talk with each other. And we're going to have to understand each other's perspectives and then find common ground to ensure that each person's rights are protected. That means that the common ground needs to be enshrined in laws and rules. And in those laws, we have to ensure that the government and private industry don't trample on the rights of the individual. We, the people, we are where the rights begin. And that pretty much sums up the philosophy that drove our approach as we worked through these issues in Worth County. And I tell you, excuse me, it took a lot longer than I hoped it would. If I were king, I could have done it faster. And I would have had some additional rules. But I wasn't king. Nobody in this room is king. So simply put, we have to recognize the reality of the situation. There's a lot of stuff about commercial wind projects that we as a zoning commission didn't know when we started. We had to talk to people about it. There's a lot that the citizens that were signing easements with the wind company didn't know about the easements that they were signing. We had to talk them through those things. So we have to talk with each other. And lastly, we have to recognize that our rules and laws governing the civil society need to change as the situation warrants. In fact, in a couple of slides I'm going to show you, the Iowa Supreme Court has said that. The Iowa Supreme Court has said they expect these laws to change. Now, let's go through just real quick a couple of the parallels between Worth County and Tama County. And this, by the way, is not unique to Worth County and Tama County. We saw this when we were doing our research. This is happening all across the state of Iowa and, in fact, the United States at large. First of all is the issue with the age of ordinances. You just heard Kathy talk about the ordinance here in Tama County is nearly a quarter of a century old. It was last approved in 2010, but it was virtually unchanged from that which was approved in 1998. This in Worth County, we didn't have a wind ordinance, we had a zoning ordinance, and that zoning ordinance only applied to 3 of our 12 townships. So 3/4 of the county had virtually no rules whatsoever. In fact, I'm going to talk about that in just a second. But what we did have in the zoning talked about conditional use permits. Now, you heard Heather talk about the open-ended fashion of the Tama County permits. Our permits were just as open-ended, and the permits for wind, the commercial use permit, just simply said you had to have a conditional use permit in 3 of the townships. The other townships, just do whatever the hell you want. There were no rules. That's all we had. That's what we started with. Now, what happened was there were some projects that came in, just as what's happening here in Tama County. Some projects coming in, people are going, whoa, what is this? And why are these things so close? And how many are there? And why did this impact? And why did that impact? In Worth County, it was a project called Freeborn Wind. It was called Freeborn Wind because that was the name of the county that the wind project was supposed to go into in Minnesota, Freeborn County, Minnesota. Freeborn County, Minnesota had rules that the energy company didn't like, so they looked across the border. They spied Worth County that had 9 townships that had no rules, no zoning, and they said, we'll go there. So they installed a bunch of them in Deer Creek and Grove townships. They made agreements with the supervisors that dealt with the use of county roads, right-of-ways, and drainage, and they verbally told the supervisors how many turbines would go in, and verbally promised the supervisors how far away they would be, 1,500 to 2,000 feet. And then when the project was over, there were more turbines than they said they were going to be. They were taller than they said they were going to be, and they were as close as 800 feet to people's homes. In Worth County and Tama County, new projects are coming in. In Worth County, it's a project called Worthwhile Wind. They want to put turbines in virtually the entire west half of the county. In Tama County, you heard Heather talk about the projects that are coming in here. In Worth County, that served to wake people up. In Tama County, it looks like it's serving to wake people up. Citizens wake up and say, we got to do something about this. We need some protections. Our rules are old. These are going to take time to address. You can't just change these rules overnight. These are complex issues. So we need to take a pause, enact a moratorium, research the issue, have the conversations with everybody, identify the rules that make sense, implement them rules, and say, okay, now submit your permit applications. As soon as you start talking about that, those new projects add the urgency and highlight concerns, and as soon as the energy companies hear about it, down here, bottom, energy companies threaten the county government. I understand it's happened in Tama County. It did happen in Worth County. As soon as the citizens' petitions went to the supervisors, and the supervisors even engaged in conversation about should we have a moratorium, should we look at updating our rules, before they even discussed what that resolution might look like, they received a letter from the energy company's hired attorney threatening litigation. As soon as it happened. We're going to talk about that now. I'm sorry? Was that did you have a question? So I'm going to use these next two slides to talk about this legal threat to our supervisors. And they're veiled in the title up there. It's called vested rights. Legal threats seem to be especially common for our rural counties. You know, the smaller counties, our county attorneys, our general county attorneys, they don't have expertise in this area. And these energy companies, you know, they've got these folks on a retainer. They're using them all the time and all the time. And the fact that their go-to approach is to threaten litigation as soon as somebody starts talking about rules or changing rules speaks quite a lot to the motivation and the character of those companies. Rather than reach out and say, look, we understand you've got hundreds, perhaps thousands of citizens that are upset, that have questions, that want to see their centuries or their decades-old rules updated. Let's talk through these things. Instead of doing that, their go-to approach is to threaten litigation and invoke a variety of additional scare tactics, frankly, many of which are false. In fact, I believe your zoning commission received a letter recently, for all intents and purposes, from the attorney of the energy company saying you shouldn't have any more zoning commission meetings talking about this stuff. It's bogus. It's got nothing to do with that. Yeah, the threats worked for them. People are scared. So I think it's time to review some of these issues associated with vested rights. The vested rights is a real thing. It's legally used to protect people that have a permit from changes to rules after the permit has been issued. So if you go to the county, you apply for a building permit, they grant you a building permit. Vested rights says that you're allowed to build your building based on the rules that were in place when your permit was issued, even if they change the rules the following week. Now, in some cases, with these larger projects that take years, that may not start for a year or 2 years after the permit was issued, they may not still have vested rights. The reality is the court will decide if they have vested rights. And what happens is the individual, the energy company in this case, if you change the rules after the permit was issued, or certainly before it was issued, if the energy company wants to claim vested rights, they petition the court to be granted an exception from your rules to be granted these vested rights. The court will go through a fact-finding process and decide the case based on the facts. And most of the time, the county's insurance company will pick up the tab for that, because when the energy company files a petition with the court, the county's going to have to respond. And so if somebody petitions the court, the county isn't necessarily going to have to pay those costs out of pocket. The insurance will pick it up. Now the reality is there's two ways that people can be granted vested rights. The first and most common through zoning is your grandfathered in. Most zoning ordinances, and I know Tama County's zoning ordinance, just like the Worth County zoning ordinance, has a whole chapter on non-conforming activities. Non-conforming activities means you have something that's in place before the rules were changed. You're allowed to keep that thing in place, even though the rules have changed. You just can't redo it again. It's your grandfathered in is the common way that it's referred to. The second way to have vested rights and be granted an exemption is, as I said, is for somebody to petition the court. So an energy company would have to file a petition with the court and say, Tama County changed their rules after they gave us a permit, or they changed their rules before they gave us a permit, or they're thinking about changing their rules before we even submit our application. We want the court to grant us vested rights to say we're exempt from those new rules. They have to go to a court and ask that, and the court will decide. The court will either rule in favor of that petition and say, yes, you're granted an exemption to those new rules, or no, you have to abide by those new rules, or something in between. And that's it. The court does not fine the county for the county enforcing its rules. The court does not fine the county because the county is taking its obligation and updating its rules as it's necessary. That's not what the courts do. That's not what vested rights is about. Now, with regard to vested rights and changing zoning laws, let me show you some things that the Iowa Supreme Court has said. So the Iowa Supreme Court said zoning is dynamic and changing, with any existing restrictions being always subject to reasonable revisions in light of changing community conditions and needs as they appear. So straight away, if Tama County is looking at their ordinance and saying, geez, this thing is pretty old, technology has changed a lot, we've learned a lot, we should probably update our zoning laws. And then if an energy company says, oh, no, you can't, you shouldn't change that. Caca. Iowa Supreme Court says these things are dynamic and changing. There's an expectation that the government, for the people, are going to update the rules as necessary to maintain that civil society. The Supreme Court has said property owners in the area affected by a zoning ordinance, as well as adjacent landowners, and I would say also as well as energy companies that own land easements, have no vested right to the continuation of the current zoning. They've got no right to say, you can't change your zoning ordinance. These two findings, these two rulings from the Supreme Court give you the basis to say, we expect our laws to be maintained up to date. The Supreme Court of Iowa expects our laws to be maintained up to date. The Supreme Court has also said a zoning ordinance, including any amendments to it, carries a strong presumption of validity. So as long as it's gone through the process, what that zoning ordinance says, the Supreme Court said, we're going to read the plain language and we assume it's valid. We assume it's valid to the extent that the Supreme Court says the challenger must show that the ordinance is unreasonable, arbitrary, capricious, or discriminatory with no reasonable relationship to the promotion of public health, safety, or welfare. Once again, the expectation is that our government is going to maintain our laws up to date so that we can maintain the civil society and protect the rights of the people. The Supreme Court has also said a moratorium aids a governing body in performing the legislative task of municipal planning. They aid in bridging the gap between planning and its implementation into legal measures. In other words, they recognize that on some of these issues, it's going to take a long time from the point in time which you say, we need to change our rules, to the time it takes to research what those changes should be, and then actually put those changes into an ordinance that is passed and on the books, can take a long time. And the Supreme Court has said a moratorium aids the governing body in performing that task. If you read on, it says they may be used to preserve the status quo while study of the area and its needs is completed, thus serving a significant public purpose. So for these complex issues that are going to take a lot of time to change the ordinance, the Supreme Court has said a moratorium is perfectly acceptable. It's a valid planning aid for you to say, we're going to take a pause on any more permits because we're going to change our laws, and then go through the process of changing them. One step further, with regard to completion of work on a project that was previously permitted. So we're not talking about projects that are maybe going to happen. This is a project that has already been permitted in this Supreme Court case. He said vested rights to continue development would not necessarily be true where the permittee had actual or constructive knowledge of the pendency of the zoning amendment at the time of the issue of the permit and the expenditures and work done under its authority. So in this case, somebody had a permit. It was taking them a long time to get started on their construction. The laws changed. The county tried to, or the city to enforce the new laws. The petitioner filed for vested rights, and the court says, you don't necessarily have vested rights just because you have a permit. You knew that the rules were changing. And you hadn't started your project yet. And the court has a variety of tests that they'll go through to determine whether that person has the vested rights or not. So with that as a backdrop, let me share some additional things that happened in Worth County. Before Invenergy, which was the company that wants to do the worthwhile wind, before they had presented even a plan to the county supervisors, they hadn't even showed them the area of the county that they wanted to talk about yet. As soon as they heard that we were talking about a moratorium and updating our rules, their legal counsel sent a letter threatening litigation and said, if you start to change your rules, or if you pass a moratorium, we're going to take you to court. In light of all of that, and with my understanding of vested rights, and I'm not an attorney, I just know how to read. And so in light of all of that, I hired a firm out of Des Moines, out of my own pocket, not the county, and asked them to draft a legal opinion on vested rights in light of what was happening in Worth County. And then I told them, I want you to send this letter to our county supervisors to educate them, because they're being threatened by this energy company, and our county attorney doesn't know anything about this stuff. He doesn't have that expertise. So I want them to have a legitimate legal opinion to help them understand what the reality really is. They got that legal opinion, and they said, I think we need to hire an outside attorney to look into this stuff for us. These threats from the energy company don't have the basis that they seem to have on its face. My point in these two slides is to say, especially if there were any of the government body folks here, I know there were two of you here, and I won't ask what parts of the government you represent. But my point is to say, don't be scared by these threats. They're an attempt to get you to give up your rights, or to get you to give up the rights of the citizens of Tama County. And they're frankly bullying tactics. We shouldn't succumb to bullies. We don't succumb to bullies in our schools. We don't succumb to bullies in our private lives. We shouldn't do so in local government either. The county supervisors, in my opinion, have a responsibility and an obligation to stand up to these threats and ensure that the rules are followed, the expectations are followed, and that the rules are updated as necessary to protect the rights of the citizens. So we're going to put the vested rights behind us. And I'm going to talk a little bit about the process that we went through in Worth County. Now, the process that we follow and the process that Tama County should be following is pretty much identical because it's dictated by Iowa law. The basis starts with Iowa Code 335.301 that establishes the authority of the county supervisors to make ordinances for express purposes. Now, I would submit that it's not just the authority, but it's a form of an obligation that the supervisors take on when they're sworn into office. They're the ones that determine what the county ordinances should be and should say. But with regard to zoning, they don't make zoning ordinances by themselves. And the Board of Supervisors can't act on their own with regard to zoning. The code establishes the authority, or the code that establishes the authority for county zoning is Code 335. It specifies in subsection 5 that zoning and associated ordinances should be designed to accomplish that which is laid out in a county comprehensive plan. And that plan and the ordinances that support it are supposed to be designed to achieve a variety of things that are spelled out in that code. Not least of which are a couple of things that go all the way back to my beginning slide, to the beginning of our Constitution. The primary purpose of government. It specifies one of the things that are supposed to, the comprehensive plan and ordinances are supposed to do is protect our rights and general welfare of the citizens of the county. So it's not just a moral obligation, it's the law. Now that section of Code 335.1, as I said, it lays out all of this stuff and identifies what these zoning laws are intended to achieve. It's very important, and I encourage everyone to read it. Search for it online, it's very easy to find. Now, it also says that the recommendations for zoning issues originate with the Zoning Commission. That's where the process starts. So the ordinance process dictated by law says, first of all, you have to start with a county comprehensive plan. That comprehensive plan goes through drafts, it goes through public hearings, it gets reviewed by the Zoning Commission. In fact, the Zoning Commission probably leads that activity if it's not a separate committee. But ultimately, that plan has to go through the Zoning Commission. The Zoning Commission makes the recommendations to the supervisors after a public hearing. Changes are then determined, and then the supervisors get to vote. With regard to the zoning ordinances and related, the wind and zoning are identical. They're supposed to carry out what the plan says. So in Benton County, if their plan says nothing on land that has a CSR of 70 or higher, well, I'm guessing their county comprehensive development plan says we want to protect our prime agricultural land, and they've identified prime agricultural land as land which has a CSR of 70 or higher. And if that's what the plan says, then it makes sense that their wind ordinance says, well, our plan says we got to protect prime agricultural land, so we're going to say you can't develop this kind of stuff on it because it takes it out of production. That's how these things are supposed to work. So with zoning ordinances, once again, they're drafted by the zoning commission. A new ordinance, a changed ordinance, a reapproved ordinance, it doesn't matter. If it deals with zoning, it starts with the zoning commission. The zoning commission has to have a public hearing, then they make their final decision, then they send it to the county board of supervisors. That's the report and recommendation that you see there. The county supervisors then have to have a public hearing, make any changes to the ordinance that they feel is necessary, and then they vote on it. Those are the steps that are dictated by Iowa statute. Now, on the next couple of slides, I had intended to provide some details on what happened in Worth County. Unfortunately, we have just the one slide, so I will read to you the last slide when I get to it. But this is the timeline that happened in Worth County. There's a lot on here, and I apologize for all of those points, and I'm not going to go through each one of them step by step. And these are just the main points on here, by the way. But it gives you an idea of the timing and the steps that were involved. In Worth County, it started in late February, early March, when the citizen petitions hit the supervisors. And the supervisors ultimately said, yep, we're going to pass a moratorium, and that moratorium is going to be in effect until July 1st of 2022. Zoning Commission, I think you better get off your butt and update our ordinances. That's what we did. Again, that start was as a result of what had happened in Deer Creek. All of those activities lasted through until June of this year, when our wind ordinance was finally approved. Now, we gave the wind ordinance to our supervisors all the way back in June of last year. But during all of this time, the energy company kept pestering our supervisors to sign off on a wholly separate agreement, telling our supervisors, you don't need to go through all of that stuff with the wind ordinance. It's not going to apply to us anyway, because we have vested rights and we're going to take you to court to prove it. So you might as well sign off on this agreement, and we'll give you a few cookie crumbs of what it is that you're asking for. Meanwhile, the Zoning Commission was talking with Invenergy representatives saying, would you read our draft? We gave them a copy of our draft wind ordinance for them to read and give us feedback, and they refused. Again, bullying tactics, they don't want to work with the people, but it tied up our supervisors for a long time until finally in late 21, our supervisors finally said, we're not signing the agreement. One of the supervisors made a motion to approve it, and it failed for lack of a second. So then they started looking at the wind ordinance that we had drafted. They asked us to make some changes to it. We made those changes. Ultimately, they approved that in June. And in the interim, between late 21 and June, we turned around and worked on the zoning issue. We had told them as early as 2020 that our zoning was discriminatory because it was only zone 3 of the 12 townships. But it took all of this to happen before they finally woke up and decided, yes, the whole county should be zoned. Now, the last slide was going to talk about our wind ordinance in particular. And the first thing that last slide says was it was a paraphrase, if you will, of what our goal was, the zoning commission's goal when we set out to craft a new wind ordinance for Worth County. Our goal was to create a comprehensive ordinance that met the requirements of law and enable an orderly process for the development of commercial wind turbines in Worth County, consistent with the principles of safety, general welfare, and preservation of prime property and citizen rights of current and future landowners. So that was the goal of our ordinance. And that theme was the underpinning of everything that we contemplated and eventually agreed to. Now, during our process, each of the 5 zoning members had an opportunity to bring up anything, say anything, agree or disagree on anything. And as I said, if each of us were king, we'd have done something different, but none of us were kings. Ultimately, what we developed, that we provided to the public for the initial public hearing and review, that ordinance was unanimously agreed to by all 5 members of the zoning commission. We went through the public hearing, we got feedback from gobs of other agencies. I'll talk about those in a moment. We made our changes, and then our final copy, again, was unanimously agreed to by all 5 of our zoning commission members when it went to our board of supervisors. Now, we spent a lot of effort and research in considering a wide range of topics, sources, and opinions. In fact, the next bullet on my slide was going to, actually there were several bullets that said, we researched 38 ordinances from around all regions of Iowa. Tama County ordinance was one of the ones that we reviewed. We reviewed state and federal guidelines related to commercial wind development. We sought and obtained input from 5 local government agencies and 2 wind development companies, including Invenergy, which they gave us an initial interview, but then declined to give us any further input or feedback on what we were proposing. We performed hundreds of hours of research of peer-reviewed scientific journals on the topics. We reviewed dozens of unsolicited input received by individuals, groups, and business entities. We provided a preliminary draft to the public and all the entities that provided input to us. And we held public meetings and reviewed and considered all the submitted comments. Now, I mentioned that we reviewed Tama County among the 38 ordinances that we reviewed from all across Iowa. Frankly, we found the Tama County ordinance was unfortunately consistent with a lot of the other ordinances that we found. They were ordinances that were written 20 years ago, 15 years ago, based on the state of technology at the time, based on the state of knowledge at the time, based on the state of experience at the time. And keep in mind, there wasn't a lot of these out there at that time, 20 years ago, and they were rather small. And when we looked at the Tama ordinance, as I said, we thought it was consistent with a bunch of the other ones that were frankly weak and out of date. And we made that determination early on because very early in our process, we sat down and created a grid of 32 individual aspects, 32 individual topics that a wind ordinance should cover. Our review of Tama County felt that we addressed 13 of those 32. I haven't counted our ordinance, we used that at the beginning, and I didn't go through our ordinance and count how many individual topics that we address in there now, but I'm pretty sure we went beyond those original 32 that we had come up with before we started. And again, one of the things that we tried to do in our research was base our decisions on authoritative sources. We didn't spend any time on so-and-so's advocacy website for or against. We also looked at what was the source of that information. There's a lot of agencies out there that brand themselves as very official, lots of members, etc., and they put out very official-looking guidance, and energy companies pass this stuff around. But as Kathy said, you have to look at these things and ask well, what is their motivation behind this stuff? And if we could identify a motivation behind that, really tailed down to a hard for or against, we discounted those kinds of things. We tried to stick to scientific, peer-reviewed journals and government guidance. We did consider those things when people gave them to us, but when it came to putting things in our ordinance, we wanted to make certain that we were on solid ground to be able to back up anything that our ordinance was calling for. Now, as I mentioned, our goal, we tried to make the ordinance comprehensive and to fill in all of the shortfalls that we felt that were in other ordinances in other counties. And we wrote it to ensure that our ordinance would try to keep pace with the change of technology. For example, many of the older ordinances simply define a setback distance. And that setback distance 20 years ago was the manner in which the effects of shadow flicker, the effects of sound, and the safety hazards were trying to be managed. The expectation was you put it X distance far away, and that's going to take care of all three of those things. The reality is those are three different things. So our ordinance dissected that. Our ordinance discusses shadow flicker, independent of sound, independent of physical safety setbacks. We also tried to make certain that we recognize that turbines are always going to change in size and scale. So our safety setbacks define minimums and then call out the greater of, so it's got to be the minimum of this or the greater of X times the total height or the manufacturer's safety distance. These energy companies buy these turbines from manufacturers. Manufacturers put in their manuals safety distances. If that turbine catches on fire, we've had 3 of them that I'm aware of in Worth County, 3 turbine fires. One of them you can still see the burned out turbine up there. The turbine manufacturers say if that turbine catches fire, you need to evacuate everybody out to a distance of X number of feet or miles, whatever the case may be. So our ordinance says, well, if the turbine manufacturer says that's what the safety distance is, then, my God, that's the safety distance, not our minimum 1,600 feet. Now, I could go on, I could talk about our ordinance for a long time and go into a number of details, but I really want to have a chance for questions from you folks. I will say that our ordinance is available online on our county website. There's a rationale document that we produced and a frequently asked questions document that we produced as we were going through this process. Those are available online. I will point out a discrepancy, if you will, between what you'll read in the rationale document and what you read in the approved ordinance. The Zoning Commission's unanimous decision and recommendation to the Board of Supervisors was that our safety setbacks were to be property line. Not homes, not buildings, not schools, property line. We believed 100% that people's rights begin at the edge of their property, not at the edge of their house. And so we wrote the ordinance to reflect that. Our supervisors decided if they went that way, it would conceivably take too much land off the table for use by wind turbine companies. And so our supervisors made changes to that. So we do still have some property line setbacks, but not to the degree that it was originally. So when you read our rationale document and you read our ordinance, you may see that discrepancy there. But our rationale document was created when we gave it to our supervisors, not after they approved it. Because frankly, once they approve it, it's their ordinance. So with that said, what questions do you have?